First, before us for our general meeting, please those in the audience while we are beginning our uh, today's general meeting for the board of the Baltimore City Board of Municipal and Zoning Appeals. On the agenda for today's general meeting is a sewage appeal for 8224 Philadelphia Road and Rosedale, Maryland. Mr. Lumasa is the appellant. Does he get a chance to speak? No. So,
Unless you want to get them there. It's up to y'all. We
Okay.
thought it was gonna be to the papers.
yeah, to the papers. We're going to keep it to the papers. I've read the papers, and we have a jurisdictional issue to address before we can consider the merits of the appeal of his sewage bill from Baltimore County. Reading the statute, under which this appeal, that gives us the authority to handle such appeals. I'm really struggling to understand how we have the jurisdiction to review a wastewater charge that was issued by Baltimore County. The particular statute reads that in the event that the particular portion of the statute is Article 25 subsection 13ZA. In the event that any particular property owner is legally liable for the payment of charges imposed under this subtitle, which is disagrees with or is aggrieved by any determination, decision, order, or notice of any kind which is made, rendered, issued, or given under the provisions of the subtitle, such property owner, within 20 days after notice of any such determination, decision, or order, may be necessary or proper to bring the matter into dispute before the Board of Municipal and Zoning Appeals for review by it. Mr. Lamassa's wastewater bill was issued by Baltimore County, it was not anything issued under the authority of, this subtitle. So, for this reason, I am going to vote that we do not have the jurisdiction to hear his appeal today.
I think it may serve us.
Did you get that?
Oh. I think it may serve us, and I'll just subject to the board's thoughts on this, to have Mr. Lamassa state what he is, if he agrees or disagrees with the position taken by the chair.
Yeah. I'm more than willing to have Mr. Lamassa speak today and tell us why it is that he believes that we have the authority to hear this matter today. So, Mr. Lamassa, I'm going to call you up.
There's two individuals from the legal department as well. If you
Okay.
wanna-
Oh, that's even great. That's even better. So we'll have the legal, Mr. Lamassa, if you can, I'll invite you here to speak, and then afterwards, I'm going to invite members of our prestigious legal department to opine on this issue also.
Well, I was told that you wouldn't be hearing any argument, and so I don't have.
Mr. Lamassa, but first, the microphone in front of you, please make sure that green light is on. Tap the button one time, make sure the green light is on. Make sure that we can get everything on the
Now
record.
it's on?
Yes. And first, I want you to swear, stand to be sworn, yeah.
Do you swear or affirm under the felony perjury that the answers that you give and the statements that you make will be the truth, the whole truth, and nothing but the truth?
Yes, I do. My position in the case is that the LLC owner is responsible for the sewage bill. And the quirk in this case has to do with the fact that the property's in the metropolitan district. And in 1924, the state legislature passed a law saying the city must provide water and sewer services to properties within the metropolitan district. And then 50 years or so later, the city and the county reached an agreement whereby at the end of the year, the county would issue sewage bills to its residents, and then they would account for that to the city DPW. And a meeting was to be held at the end of every calendar year where they would hash out various and sundry issues that were under dispute. The dispute in this case was that almost all of the sewage discharge was cooling water, which is, in the county law, is not subject to a sewer service charge at all expressly. And under the city law, it's not, it's silent on it, but the city law does provide that the city can charge for sewer charges for sewage, wastewater, not cooling water. So in the case in the county, the issue was raised, and the director of the Metropolitan District petitions and I can't even remember the rest of his title. He testified, and he said that the county was required to account to the city for every drop that went into the water meter, into the property, and they relied on a presumption, which we're getting a little far afield now, doesn't really apply here. They had to account to the city, and the city had, or the county had to pay the city for every drop of sewage. Now, in this case, the issue of cooling water was basically disregarded. And that's a legal matter that has to be hashed out in the county proceeding. There was never a ruling by the board on it. They just said, we affirm DPW, and that was that. So our position is that the county had the opportunity to invoke Article 25, Section 13.6 itself. And they didn't do it, and questions were asked in the transcript, and that it was submitted. It was filed this morning as a supplement to my Sunday email in answer to Ms. Tucker's question on third-party beneficiaries. Third-party beneficiary contract law came into play as well, somewhat. And we invoked it, saying that the property owner is the party that's ultimately responsible for this sewage service charge, and the city receives it from the property owner indirectly from the county. So that being the case, the property owner should have the right to question and to ask for a consideration of unusual or extraordinary circumstances that might influence the amount of the bill. The bill in this case was $27,000 sewer charge. And then there was part of a following year, which is subject to a second proceeding in the county, that was for $24,000. And it happened because a refrigeration part broke of a water-cooled freezer, broke in the open position, and a full flood of water went into the sanitary sewer over the period of a year. It turned out to be 2,990 units of water, which was something over 2 million gallons of water in calendar year 2023. In calendar year 2024, it was somewhat less, but it was still added up to $23,000. So it was a significant amount of money. So we wanted to have the director of the Department of Public Works in the city. There is no applicable or no similar provision in the county law, but the county was unwilling to consider it at all. They're just saying, this is the way we do it, and that's all there is to it. And the board just said, that's the way the system's set up, we affirm. So we've never gotten an answer, and that's still undetermined because the case is still alive. So I filed this appeal in this case as the ultimate, as the lawyer for the LLC that owns the property, asking the city DPW director to make a ruling whether these circumstances justified a rebate. And in April of this year, they said, we can't consider it because it's in the county. And our argument is that exalts form over substance. The substance is the property owner in the county is responsible for the bill and pays it. The county just receives it in the right hand and pays it with its left hand to the city. So the city receives it so that they shouldn't have an objection to determining whether fairness dictates whether there should be a rebate or not. And the technical matter of who issues the bill is kind of made unclear by the existence of the Metropolitan District and this 1974 sewer agreement, which provides also that there can only be a charge for sewage, not cooling water. And these issues were raised in the county proceeding and disregarded. And the answer to that question is still up for grabs. It's not final. So we think that the Director of Public Works should have considered the question. Now, the jurisdictional question is a little, I think, easier to rule upon because Article 7, Section 86 of the Charter of Baltimore City gives the board the power to hear a ruling from any department. And the ruling of the director of DPW on April 8th was a ruling. So I think the board has jurisdiction to hear it. Now, how you're going to rule is another question, but you have the power to hear it. Also, Section 13.6 also says in all cases, the director of DPW has the power to consider unusual or extraordinary circumstances. But he's refused to do so in this case. And then 13.7 gives an aggrieved property owner the right to appeal it to the board. And that's it in a nutshell. There are a lot more details, but I think that's the gist of it. If you have any questions, I'll be happy to respond.
Anybody have any questions at this moment?
Not right now.
Mr. Lamasso, just so that I understand your client's need at this time, and then I'll also have questions for the BMZA staff. We're here today to determine whether or not Baltimore City has the authority to rule on this because ultimately, as your client takes this case to court, it needs to have a clear jurisdiction, essentially. And so what you're here today is for the city to say, it is our jurisdiction. The client, even though their business is registered and located in Baltimore County, has the right to appeal to Baltimore City about the charges, and that's the decision you need to move forward with your case. Is that correct?
Yes.
Okay, I just wanted to clarify why we're here.
It's an indirect payment to the city through the county.
And our ruling will then create legal basis, essentially, for your case to move forward.
Well, if
in your opinion, that's, yeah.
If you were to rule in our favor, the director of DPW for the city would have to take a look at this and see what he thought about it. This isn't a ruling on the merits of the case. It's only whether DPW should consider it.
Okay, thank you for that clarification.
You're welcome.
Thank you, Mr. Lawson. I'm going to hear from the legal department. Who's up? That's where attorneys. You're good.
Okay, it's on?
Yeah.
Okay. Good afternoon, everybody. I am Adam Levine, the Baltimore City Law Department, and I think the confusion that we have is that appellant assumes there's a connection between Subtitle 13 and the 1974 agreement between the city and the county. So let me just talk about those two things and how they're different. Before I do want to make one point and back up a second. He mentioned a charter provision that gives the BMZA the authority to review decisions by other city agencies. But what appellant left out is where provided by local law. the board doesn't review decisions by all city agencies. The city council is a city agency. If the city council passes an ordinance, the board doesn't review that because it doesn't have the authority under local law to do that. The Board of Estimates is a city agency. The BMZA doesn't have authority to review Board of Estimates decisions either. It only has such the charter gives the city council and the mayor authority to give the board the power to review decisions by city agencies. And the land use article, gets separate from the city doing so, gives the board authority under state law to hear zoning cases. But the board doesn't simply have broad authority to review any decision by any city agency. It has to be provided by local law. The local law at issue, which appellant relied on here, is Subtitle 13. Subtitle 13 is limited in 13-1 to sewer bills that the city issues to properties located in the city. That's a phrase taken out of 13-1. And then I think earlier you quoted 13-7, which is the board's authority to review decisions of DPW, which is limited to bills that a property owner is liable for under Subtitle 13. The city hasn't issued a bill to appellant under Subtitle 13. Similarly, the city doesn't issue a bill to the county under Subtitle 13. I think appellant is suggesting that appellant should be able to make a challenge that the county has a right to make but just has refused to do. But the city doesn't issue a bill to the county under Subtitle 13. How do I know that? Because 13-1 says all properties located in the city. The county owns a sewer system, but that sewer system is located in the county. So we don't issue them a bill under Subtitle 13. What we do under the 1974 agreement is we negotiate with them on a yearly basis with regard to the shared sanitary sewer system. They send, ultimately from their system, all of their sewage water into the city system to be treated at the municipal treatment plants. And based on those costs, as well as a slew of other costs that are listed in this agreement, and there's a formula for determining them, including construction costs and debt servicing, average sewage flow, all those things, the city and the county get together, they negotiate an overall cost that one party has to pay the other. I assume it's probably the county paying the city every year, but I'm not involved in that process. But that exists completely outside the world of Subtitle 13. And even assuming that I don't think that appellant is a third-party beneficiary under this agreement, because it doesn't mention any other party under the agreement as to which the benefits of this agreement would apply. But even assuming that appellant was, if there's a dispute under this agreement, under Article 16 of the agreement, it goes to arbitration. So even assuming that appellant can somehow take advantage of this agreement, this has a provision for resolving disputes. It doesn't go to the board. It goes to arbitrators that are selected by the parties to the agreement. And so with respect, I think, it's an inventive, creative argument, but I think appellant is just trying to bring together two things which really sit outside of one another. Thank you. Unless you have any questions.
Yes. Any other questions?
No questions.
No questions.
No.
Does anybody have any follow-up questions for the appellant?
No.
Given the testimony we've heard today by both the appellant and the opinion of the city law department, I think it strengthens my position that I do not believe that we have jurisdiction to hear this matter. And so for that reason, I'm going to deny the appeal.
I believe, I agree with our chair. Based upon the papers and the testimony given today, I don't believe there's jurisdiction of this appeals board to rule on this, number one. And number two, I'm not convinced petitioner is a third-party beneficiary.
I agree with the chair. I deny the appeal.
And I am also in agreement of denial.
Thank you, guys. Do we need a break, or we ready to go into the docket for the day? Okay.
Maybe be.
Yes. It's 1:09 p.m. We're going to begin our zoning docket for today. First, we have for planning. Yes.
Planning just would like to request, if it's agreeable to the board, that 250066 be heard first. We have our critical area planner here to address any questions you have.
Of course, of course. So now calling 250066, 5911 Pennington Avenue. The purpose of the appeal is to use as an industrial general requiring conditional use and off-street parking variance approval. Ms. Drew Tilden for the appellant. First, we'll hear from planning and staff. Thank you.
Thank you.
Yeah, exactly. Thank you. Make sure I check the boxes.
Okay, good afternoon. Justin Walker with Department of Planning. Here today on case 25-0066, 5911 Pennington Avenue. The request is a conditional use approval to use the property as a general industrial use, as well as an exemption to the prohibited uses in the critical area. So we understand that the applicant proposes 360,000 gallon butane storage vessels on the property, which again falls under the industrial general use. So that is a conditional use. It's an expansion of the existing use at the site, which planning finds that the standards of section 5-406 were met for this, and recommends approval in that regard. Also, per section 14315 of the code, for conditional uses that are approved in the MI Marine Industrial Zoning District, which the subject property is located, the findings have to be made that there's a deep water component that requires waterside access by vessels or barges to and from the property, which the applicant has stated the property owner does receive vessels and barges to appear on site, so that requirement is met. The largest findings that needed to be made were under section 7-406 of the zoning code, which includes uses that are prohibited within the Chesapeake Bay critical area, which this entire property is contained within. Among the prohibited uses are the collection, storage, handling, or disposal of hazardous or toxic materials, which the butane tanks would qualify. Under subsection D, there are exceptions to that prohibition that can be made on the recommendation of planning and the finding by the board that, one, there's no environmentally acceptable alternative outside the critical area, and that the use is needed to correct an existing wastewater quality problem. Planning has made both of those findings. The entirety of the property is within the critical area. It is bound by I-695 on the south and west, and by the water to the north and east. So there's no feasible alternative outside of the critical area. Regarding the existing water quality problems, planning found that the storage vessels would allow, they currently unload butane from trucks that sit on site and idle, do the whole unloading process, and create a queue of trucks on the site. Having the storage vessels would allow the trucks to immediately unload and then be on their way, reducing the water quality problems of having those trucks idling on site for longer. In addition, the applicant states that about 15,000 square feet of impervious surface will be removed and replaced with natural turf, and that will result in a reduction of nitrogen, phosphorus, and suspended solids on site, which is a water quality issue. So given those findings, planning recommends approval of the appeal, as we have found that they meet the standards of section 7406 for exemptions for uses in the critical area. And again, our coastal area planner, Grace Hansen, is here, should the board have any questions.
Amazing. Hello, Mrs. Hecker.
Good afternoon. Caroline Hecker, Rosenberg Martin, on behalf of the applicant.
Yes. Tell us what brings you here today.
All right. Well, Mr. Walker did an excellent job explaining the application, the various legal standards here. I have with me Rochelle Smith from Buckeye Partners and also Tony Corteil from MK Consulting Engineers, our civil engineer, if we need technical expertise. With your permission, I'd like to proceed by way of a proffer. They can certainly answer questions. There's a lot of overlapping legal standards that the board needs to make findings on, as Mr. Walker indicated. And we've submitted a binder that sort of, I've tried to make this understandable. There's a lot of different things that the board has to find. We've broken it down into different sections and included a series of exhibits at the back. I think what I'd like to do is sort of walk through what the project is. And then I'd like to sort of hit the big items in the findings of fact, but submit the draft findings of fact. There's a outline that goes through all of the findings the board's required to consider and make in approving this appeal. They're all in the written materials that we've submitted. And so I know there are other cases on the docket today. I'm happy to go through all of them in detail, but it will take a while if I do. So you can cut me off if you feel like I'm going on too long.
Appreciate that.
So I guess to start, Buckeye Partners is one of the largest independent liquid petroleum products pipeline and terminal operators in the country. They receive liquid petroleum products from refineries, connecting pipelines, vessels, rail facilities, and marine terminals, and transport the products through a network of pipeline systems to markets throughout the Northeast Corridor in the Midwest. So what they're proposing to do here is install three 60,000-gallon butane storage vessels on a portion of the property in order to streamline the butane blending process at the existing terminal. This is an $11 million capital investment, and in addition to the construction jobs that'll be created during the construction process, it will actually add a couple of new positions to the existing terminal facility. So in order to complete this project, there are three types of approvals that we're requesting today. The first is a conditional use approval to allow the proposed butane storage vessels, which are classified as industrial general under the zoning code, which is a conditional use in the MI zoning district. So that requires conditional use approval from this board. We're also requesting a variance from the city's critical area management program manual to allow the expansion of a grandfathered use. This is a grandfathered use since it's been in existence since the 60s. And we're finally seeking an exception from the zoning code prohibition on the installation of new petroleum terminals, petroleum gas terminals, in order to allow the installation of these butane vessels on the site. I also want to clarify on the board's docket today, it indicates that we're seeking a parking variance. We don't need a parking variance here. My understanding is that was added by the board staff based on a belief that we are providing too much parking on site. There are currently about 10 parking spaces on site that are existing. They're being relocated to a different part of the site, and they're being reduced by 2. So we're going to end up with about 8 spaces. So we don't technically need a variance because what we're ending up with is a reduction in the number of spaces that are currently existing. So I just wanted to make that clarification. The property is located in Curtis Bay, adjacent to Cabin Creek. And you'll see in the file at Exhibit A, there are some aerial images showing the existing facility in a few different views. You can see the sort of large tank farm where the petroleum gas tanks are located. And then on the sort of, I don't know what direction it is, but the lower left corner of the property is an area that's improved with an office building and a parking lot. And that's the area where we're proposing to install these tanks. There's a zoning map that's included as Exhibit B that shows that the whole area is zoned MI, it's maritime industrial, the whole site is located within the critical area as well. Exhibit C is the tax plat that shows the boundaries of this property. And again, the part that we're talking about is the sort of lower left portion of the property. The total Buckeye facility here is about 83 acres. It includes not just this property. Oh, thank you, whoever's driving the, thank you. The total site's about 83 acres. This property is a little over 17 and a half acres. And the whole facility includes the storage tanks, some containment dikes, the truck transfer loading racks, and the associated pipeline. It also includes deep water access. You can see the marine terminal out there as well. The property was originally authorized for the petroleum gas terminal back in 1968. Exhibit D in the file shows the zoning cards that show that original approval back in the 60s. And so this is, and we'll talk more about this in a bit, but this is clearly a grandfathered use. It's an existing conditional use that we're proposing to expand. The way it works right now is that butane blending, which is what is occurring here, is a standard part of the gasoline production process. What happens is that you've got these big petroleum tanks, and you have trucks that come in onto the site and connect by way of a hose. In that, if you see that sort of rectangular building at the sort of left side of the tank farm site, around that building, the trucks will pull onto that site, and they'll connect by way of a hose to the piping, which you can sort of see runs to the tanks, and then the blending occurs at the tanks. While it occurs not in a uniform time period, the amount of butane that the tanks can take depends on the air temperature, so it varies seasonally. Sometimes there'll be trucks backed up, idling there, waiting to be unloaded, the butane to be unloaded, to be pumped into the tanks. And what we're proposing to do here is install three permanent tanks so that we can regularize the truck traffic that comes into the site. So the trucks will come in, they'll unload. Instead of pumping directly into the pipes and then into the tanks and having these other trucks that are queuing up waiting to unload, we'll be able to regularize the delivery of butane to these new storage vessels so that it can be delivered to the tanks in an even fashion throughout the course of the year. We won't have these sort of periods of peak traffic coming into the site with the trucks backing up. Exhibit E in the file here is the proposed site plan, which shows the location of the three tanks sort of in the upper left corner of this corner of the site, the existing building, which is proposed to remain, the relocated parking along the front of the site, and then you'll see we're including some new landscaping, some new street trees. We're reducing the amount of impervious area. We are reducing impervious area by almost 15,000 square feet, which, as Mr. Walker indicated, results in a reduction of total nitrogen, phosphorus, and suspended soils on the site. And the additional street trees will help improve the environmental quality in the area as well. Exhibit F in the file is a critical area, Chesapeake Bay critical area report prepared by Holly Oak Consulting, which reviewed the application and arrived at the conclusion that there would be no adverse impacts on water quality, habitat, or wildlife, and that the water and habitat quality within the critical area will be improved by removing the impervious surfaces and by planting the street trees. We've reached out to the local community associations, the Curtis Bay Community Association, Action Baybrook, the Greater Baybrook Alliance, as well as Councilwoman Porter and the Baltimore Industrial Group. We've heard no substantive feedback from any of the community groups or the councilwoman. We do have a letter of support that's in the file from the Baltimore Industrial Group, which I think is the last item that's in the file as well. And we'll talk more about this later, but just while we're at it about things that you'll see in the file, the project was required to be submitted to the Critical Area Commission, and there's a letter from them in the file as well regarding the application. They're sort of neutral on it, but they defer to the board's decision on this. So as I mentioned, we are requesting three different types of approval, and I'll go through them each in a little bit more detail. The first is the conditional use approval for the industrial general use. This qualifies or would be categorized as industrial general under the code. That includes the storage of large volume of toxic or highly flammable matter, which is butane, which is what's proposed here. And as Mr. Walker indicated, Section 14.315 of the zoning code requires industrial general uses within the MI district to have a deep water component. Here we do transfer product from the existing marine terminal here into the tanks on site, and so this is part of that deep water component for the industrial general use. The second one that the second piece of relief that we're requesting here is the critical area variance to expand the grandfathered use. Under the city's critical area management program manual, the CAMP manual, any use that lawfully existed as of January 4th, 1988 is considered grandfathered. This use was established in 1968, so clearly it's well within the grandfathering period, so the board has the authority to approve the expansion of the grandfathered use. And then finally, we're requesting an exemption to the prohibited use within the critical area of petroleum gas terminals that they're currently listed as a prohibited use within the critical area. But the board is authorized to grant an exception to that for, where you meet certain criteria, which again, I'm going to go into in more detail when I get to the actual findings. All right, so starting with the industrial general conditional use, and I can direct you to tab 3 in the file, goes through all of the findings that the board's required to make here. There are overlapping requirements between the conditional use standards that are set forth in section 5406, the state's natural resources article in Title 8, Subtitle 18, COMAR, Title 27, the city's CAMP manual, and the zoning code specific requirements for conditional uses within the critical area, which are set forth in 7414C. So there's sort of a lot to cover, like I said. Again, you can stop me when you get bored, but I'll sort of start going through these things. They get repetitive. A lot of them cover the same type of material, and a lot of them are things you've heard before. So the first is that, the nature of the proposed site, including the size, shape, and proposed size, shape, and arrangement of the structures. Again, the nature of the site, this has been a petroleum storage and transfer facility since 1968, as demonstrated by the zoning cards. When we're talking about locating new butane storage vessels, the best location to locate them is going to be next to the existing petroleum gas terminal, like within the boundaries of the same facility. It doesn't really make sense for us to locate them elsewhere because we would still have to truck in the butane and run the same operation where we're idling trucks while we're pumping the butane into the tanks. So this is really like the best location for it. It's on a portion of the site that's currently unimproved. And it's going to allow us to improve the environmental situation, at least by reducing the impervious surface and installing some new street trees. In terms of resulting traffic patterns and the adequacy of proposed off-street parking and loading, we've talked about the fact that in the current condition, the trucks are queuing up and idling while they're unloading the butane. So by allowing the new butane storage vessels to be constructed on site, this will eliminate that need for the queuing to occur, and it will allow a more regularized delivery of butane to the site. So we'll be able to even out that traffic. I don't know that it'll ultimately result in fewer trucks, but it'll result in a more even delivery, so you don't have these peak periods where the trucks are coming in high volumes. The nature of the surrounding area and the extent to which the proposed use might impair its present and future development. This is a very heavily industrial area. It's been a heavily industrial area for many years. Again, the property has been used as a petroleum gas terminal for over 60 years. And so we don't expect that the installation of these tanks is going to have any material impact on the surrounding area or impair the present or future development in any way. There are no dwellings, churches, schools, public structures, or places of public gathering located in the proximity of the property. We don't expect that there will be any impact on accessibility for emergency vehicles or accessibility of light and air to the premises or to other properties in the vicinity. The site is well served by public facilities and access roads. By regularizing the truck traffic to and from the facility, we expect that will actually improve the situation on the adjacent roads. And again, the project will be reviewed by all city agencies in connection with its permit application eventually to confirm that there are no other adverse impacts on public facilities. There are no cultural or historic landmarks in the area. Again, the character of the neighborhood is industrial in nature, and this is within the heavy industrial, maritime industrial zoning district. So we think this is entirely consistent with that zoning. The city's master plan identifies the property as industrial, which is defined as having an industrial character and industrial uses. This, again, falls within the industrial general definition under the zoning code, so it is consistent with the city's master plan. There is no urban renewal plan in this area. It is otherwise consistent with the standards applicable to the zoning code, which, again, we're going to keep going through them because there's a bunch of them. And it is in harmony with the purpose of the code, which is to ensure that the visions set forth in the master plan are implemented by land use regulations that are consistent with the goals. Again, this is consistent with the industrial designation under the city's master plan and the historic use of the property. So we think that this, at the end of the day, this will be, it will not impact the general welfare in any type of negative fashion. So after considering all of those factors, the board's required to make 4 findings. The first is that the establishment, location, construction, maintenance, or operation of the conditional use would not be detrimental to or endanger the public health, security, general welfare, or morals. Again, we don't think that the proposed butane vessels will have any external impact on the existing facility other than perhaps improving the traffic situation. So we think that there won't be any negative impact on health, security, welfare, or morals. And again, the critical areas report that you have in your file shows that there will be no adverse impact on water quality, habitat, or wildlife as well. You're supposed to find that the use will not be precluded by any other law, including an applicable urban renewal plan. Again, this is not located within an urban renewal plan or an urban renewal area, and it is consistent with all of the other codes, which we're going to talk about some more as we go through this. It's not in any way contrary to public interest. It is going to result in the removal of over 14,000 square feet of impervious surface, which will be replaced with natural turf, resulting in significant reductions in nitrogen, phosphorus, and suspended soils. And we're also planning to add some additional street trees, which will improve both the environment and the property's appearance. And finally, that the authorization is in harmony with the purpose and intent of the zoning code. It is in harmony with the goal of ensuring that the visions set forth in the master plan are implemented by the land use regulations. Again, this is consistent with the definition of industrial general within the code and the industrial designation in the master plan. Within the critical area, there is an additional finding. The board is required to make a written finding that the applicant has overcome certain presumptions that are in the natural resources article. So I want to, and again, this is in the written materials that we've submitted, but I just want to highlight that the natural resources article is intended to foster more sensitive development activity for certain shoreline areas to minimize damage to water quality. Again, there's a presumption that that is not occurring here. We believe we have overcome this presumption. We are not minimizing damage to water quality. We are, in fact, improving water quality by removing the impervious surface, adding the street trees, and reducing the truck idling that's going to be occurring in and around the site. And by concentrating the operation of the terminal within the existing boundaries rather than expanding it further out and requiring the trucks to continue to come into the site. Okay, that covers the conditional use portion. I'm going to pause there and see if anybody wants to ask any questions about that before I move on to the critical area variance.
No questions.
No.
Okay,
Questions?
thank you.
I don't have any questions.
All right, then I'll move on to the critical area variance that we're seeking. This is for the expansion of the grandfathered use. The general variance standards are set forth in 5308A and B of the zoning code. The board has to find that because of the particular physical surroundings, shape, or topographical conditions of the specific structure or land involved, an unnecessary hardship or practical difficulty would result, as distinguished from a mere inconvenience if the strict letter of the applicable requirement were carried out. Here, our peculiar condition arises from the fact that the petroleum terminal was established in 1968, well before the enactment of the Chesapeake Bay Critical Area Act. By definition, the butane blending has to occur on the site where the petroleum gas tanks are located. Otherwise, we're going to continue to have the trucks coming in and out. And so it's really the location of the existing petroleum tanks that was established long before the enactment of the Critical Area Act that is making the property unique and driving the need for the variance. It's creating the practical difficulty in terms of locating these butane storage vessels within the critical area. If Buckeye were prohibited from streamlining its operation by installing the vessels on this site, we're going to perpetuate the inefficiencies of having the trucks coming in and idling while they unload the butane into the tanks to complete the blending operation. There are some additional findings the board's required to make. The first is that the conditions on which the application is based are unique to the property, and they're not generally applicable to other properties with the same zoning classification. The location of the existing tanks here is unique to this site. It's not generally applicable to other properties in the MI district. The unnecessary hardship is caused by the code and has not been created by the intentional action or inaction of any person with a present interest in the property. Again, this is caused by the construction of the petroleum gas terminal in the 60s, well before anyone who's currently involved had made any decisions, and well before the Critical Areas Act was enacted. So it was not caused by any action of anyone with a present interest in the property. The variance is not based exclusively on a desire to increase the value or income potential of the property. Really, what we're trying to do here is streamline the operations again, so that we don't have the truck traffic, coming and idling there while the butane blending operation is ongoing. So it's not based on the value of the property. It's really about streamlining the operations here. The variance will not be injurious to the use and enjoyment of other property in the vicinity or substantially diminish and impair property values in the neighborhood. Again, we don't think there's really going to be much of an impact on anyone in the neighborhood, but we will say that this does improve the traffic condition in and around the property. So to that extent, it will be a net upside for the general area. The variance is in harmony with the purpose and intent of the code. Again, it is consistent with the purpose of the code to ensure that the comprehensive plan is implemented by land use designations, which is what we're doing here. It's not precluded by an urban renewal plan, as we've discussed, or the city's comprehensive master plan, or any historical and architectural preservation district. As I've said, it's not in an urban renewal area, it's not in a historic district. And we've talked about the master plan several times now, and it is consistent with that. The variance will not otherwise be detrimental to or endanger public health, security, general welfare, or morals, or be contrary to the public interest. Again, we believe that this is consistent with public health, security, general welfare. We don't think there's going to be any negative impact on the public interest by the installation of these butane storage vessels. In approving a variance, the board is also required to consider and that the applicant or determine that the applicant has overcome the presumption that the specific development activity does not conform with the general intent of the local jurisdictions program. This is under state law. So there's a presumption that the application will not improve water quality. Here we believe it will improve water quality because we are removing a little over 14,000 square feet of impervious surface. We're replacing it with natural turf. It's going to result in a reduction in nitrogen, phosphorus, and suspended soils, as indicated in the critical areas report that you have in your file. There's also a presumption that it will not conserve habitat while accommodating growth and revitalization. We believe here that it will conserve habitat, again, for all the reasons I just talked about with the reduction of impervious surface, but also the installation of the new street trees, and the reduction of the truck idling will help to the extent that there is any habitat in that area. And finally, there is a presumption that it will not promote a more attractive and sustainable environment. Here, we believe we will definitely have a more attractive environment and more sustainable. We won't have the trucks idling. We'll have new street trees installed along Pennington Avenue. So we believe that we have overcome that presumption as well. Board is also required to consider the recommendation of the Critical Area Commission. Exhibit G in the file that you have out in front of you is the letter from the Critical Area Commission. It's a fairly neutral letter, but I will note that that's better than what we get sometimes, where they come out against any kind of construction within the critical area. Here, they're deferring to the board, and they're saying that if this board finds that we meet the required standards, that it should be approved. So that has been accomplished as well. Under COMAR, there are an additional series of standards for variances within the critical area that the board is required to consider. Again, some of these are a little bit repetitive due to special features of the site that a literal enforcement of the critical area program would result in an unwarranted hardship. Again, the special conditions of the site is due to the fact that this petroleum gas terminal was constructed in the 60s, and so it's already located within the critical area at the time that the Critical Area Act was passed. So we're sort of limited to property that's located within that special critical area. But we think that having these butane vessels on site will allow us to streamline the operation and regularize the delivery of butane to the site, which will result in a net positive benefit for everyone. The second is that a literal interpretation of the local critical area program would deprive the applicant of a use of land or structure permitted to others in accordance with the provisions of the plan. Here, if it was a new facility, we wouldn't be applying for this variance. But because it's an expansion of the existing grandfathered use, that's what brings us to the need for the variance. So here we are. So, and any other applicant who is doing this from scratch would not be in this similar situation. The third thing is that the granting of the variance would not confer upon the applicant any special privilege that would be denied by the local critical area program to other lands or structures in accordance with the provisions of the local critical area program. Again, this is an intensification of an existing grandfathered terminal, which is essentially non-conforming. If they were not, if it was not an existing grandfathered use, it would qualify for the exception that we're also applying for and that you'll hear more about in a minute. So we're not, the approval of the variance would not confer upon Buckeye any special privilege that would not otherwise be available to other owners within the critical area. The variance request is not based upon conditions or circumstances that are the result of actions by the applicant. Here, again, this is due to the fact that the existing petroleum gas terminal was established many, many years ago. And so, again, we're limited to the area where these butane tanks vessels can be installed. The variance request does not arise from any conforming or non-conforming condition on any neighboring property. This is entirely due to our property's condition. It has nothing to do with the neighboring properties. Neighboring properties, for the record, are consistent types of uses. There are no, as we've talked about, no residential structures, churches, places of public gathering anywhere in the vicinity. It is all a very heavily industrial area. The granting of the variance would not adversely affect water quality or adversely impact fish, wildlife, or plant habitat within the local critical area. Again, the critical areas report finds that it will improve habitat, it'll improve wildlife. We're reducing the impervious surface and, as I've said, reducing nitrogen, phosphorus, and suspended soils. And we're installing new street trees, and we're not going to have the trucks idling anymore out front. So that's all going to positively affect water quality, not adversely affect it. The granting of the variance would be in harmony with the general spirit and intent of the critical area law, which we believe it will be. The purpose of the critical area law stated in the law is to foster more sensitive development activity for certain shoreline areas to minimize damage to water quality. And this project accomplishes that by, again, reducing the impervious area, installing the street trees, minimizing damage to water quality. Really, this project will improve water quality overall. And so we think that this does meet that factor as well. And then finally, the board is required to consider the same zoning code variance standards that we've been through. I'm not going to go through them again, but just for the record, that is laid out in your file as well. I will pause there for a second before we get into the third item that we're requesting relief on, which is the prohibited use exception. Let's see if there are any questions before I keep going.
No question.
No questions.
Thank you. Sorry, I know this is a lot. We're almost done, I promise. All right, so the last thing that we're requesting relief from, this is actually much shorter, is an exception from the critical area's prohibited uses, which are set forth in the zoning code. Section 7406D of the zoning code gives this board the authority to approve exceptions to the things that would ordinarily be prohibited in the critical area. Petroleum gas terminals are among the lists among those uses listed as prohibited uses in the critical area, and so we are requesting an exemption to that. The board is required to find that there is no environmentally acceptable alternative outside the critical area. Again, if we were to identify a site that was outside the critical area for these butane storage vessels to be located, we would still have to truck in the butane to be blended into the petroleum gas tanks. So it wouldn't solve the problem of having the trucks, the truck traffic coming in and the trucks idling on the site. So there really is no environmentally acceptable alternative other than having these butane tanks located within the critical area. Our whole site is located in the critical area. And then the second thing the board is required to find is that the use is needed to correct an existing water quality or wastewater management problem. And again, we believe that the removal of the impervious surface and the reduction of total nitrogen, phosphorus, and suspended soils will correct water quality problems. In addition, the installation of the new street trees will result in, will result in a better habitat situation along Pennington Avenue and improve the water quality all around. And then finally, the not having the trucks idling in that area will also improve water quality conditions in the area as well. And again, this is all set forth in the critical areas report that is attached as, I think, Exhibit F in the file. So for all of these reasons, we respectfully request that which is a lot, that the board approve the three items that that we have requested approval for today, the conditional use to allow the industrial general use, the variance from the critical area management program manual to allow the expansion of grandfathered use, and the exception to the prohibited uses within the code. And I'm happy to answer any questions. As I said, we have a representative from Buckeye here, as well as our civil engineer, if there are technical questions. I know I talk fast. I was trying to get through this in a way that would get us through it this afternoon, so happy to answer any questions that you may have.
I just want to get clarity on the parking issue so we can get alignment on that. So in the notes, it talks about the need for an exemption. Amanda, can you expound on that a little bit from the notes in the file so that we can align with Ms. Hecker?
So the exception and the variance are two different. So we, based on the plans that were submitted to us, they had too much parking, but apparently they changed that, and so they're going to 8, which is the acceptable amount of parking spaces they can have. So that's no longer a problem, but something I wasn't able to note in my memo is that they're seeking a variance to the camp requirements. That was news to me, so it's not in there, just so y'all know.
Okay. But that was in the planning memo.
Yeah. And if I can just elaborate a little bit further, I think part of the confusion was that the staff didn't have an existing conditions plan to see what's there currently in terms of the parking. You can see in Exhibit A, there's an aerial photo at the bottom of the first page that shows like what the existing condition is. The parking is there right now. We are reducing the number of parking spaces to 8.
That's fine. I just wanted to get on the record that staff and legal representation was in agreement.
Okay. So, thank you for,
Sorry, there is one more thing I need to know. Is if there's a best management practices plan that will achieve a net improvement in water quality and habitat?
Yes.
Yes.
That's part of our permit submission. Yes, there will be a best managed.
Perfect, thank you.
Yes.
okay, let's start with the conditional use.
Feel free to just adopt the proposed findings.
I do want to say that we would like to accept your proffered evidence. I want to thank you for, I think, relatively quickly walking us through what we had to decide today, which is quite complex compared to what generally we see for our simple conditional uses and variances. So we're starting with a conditional use industrial general. Of course, you know, there's the Schultz v. Prince standards, but I want to sort of maybe walk through some of the factors a little bit more completely today, just so we can have a substantive record. In general, you know, I do not believe that the installation of these sort of tanks will, you know, cause adverse effects that would be go above and beyond what we would typically expect of such a project in a industrial in the industrial general zone in South Baltimore. I want to speak to the nature of the proposed sites. I've considered all of the factors that we have to consider. The nature of the proposed site, this has been continually in use as a petroleum storage facility since 1968. It will result in perhaps improved traffic patterns in the sense of we should get a net negative in idling time by vehicles who have to use the facility. This is, of course, in the South Baltimore the industrial portion of the South Baltimore Peninsula, which is, you know, sort of improving, you know, an existing use within that, which I think is something the code wants to see. And because of that, it's not near any churches, dwellings, except, et cetera. It's still accessible to emergency vehicles. Does not impair the accessibility of air and light. There are no cultural, historic landmarks. and it is a fit with the character of the neighborhood and supports the city's comprehensive master plan, which wants to find a way to more efficiently continue to use the existing industrial space within the city. Of course, there's no urban renewal zone. So, in getting into the more to the additional factors, the establishment of this facility is not detrimental to, or nor does it endanger the public health, security, or general welfare. There is evidence that, in fact, that it will lead to not only a net negative in idling time of potential vehicles, but also reduced reduced impact in the water and things of that nature. So, so I accept those. It's not located within an urban renewal area. Is not contrary to the public interest. In fact, this is an important function that this facility has for not only locally but also regionally. And so it's in our interest to find more ways to sort of efficiently conduct these services. And I find that it is in harmony with the purpose and intent of the zoning code. So, but because this is in the critical area, there are additional use standards that must be considered. We are required to make a written finding that the applicant has overcome the presumption of non-conformance, and accepting your report, the reports of your consultants. I think this is definitely competent evidence that sort of rebuts that presumption of non-conformance. I think this will foster a more sensitive development activity for the shoreline. The reduction in impervious surfaces, the addition of street trees, I think, are small, but sort of important ways to show that even with simple projects like this, we can find a way to make better use of this industrial land for our environment also. And I think would also promote consistent, uniform development along the city shoreline. We'll continue to keep this use contained within the area, but also improved. And so for those reasons, I am a yes on the conditional use on approving the conditional use.
I'm a yes.
I'm a yes.
And I'm also yes.
Did we knock everything out on the conditional use portion? Okay, so moving on, we also have, what is it? An exception to the critical use area prohibition on this use. We are dealing with it's important for us to note that we are dealing with a grandfathered use. This has been in continuous use since 1968. The general variance standards, of course, we have to find something unique and peculiar about the property. And it's my position that, sort of a pre-existing use from 1960 of petroleum sort of, storage facilities in this area is sort of unique for other industrial general areas throughout the city. This is a really specialized use that is, sort of specialized to this part of the South Baltimore Peninsula. It is, the zoning code itself and the requirements and additional requirements because of its location in the critical area sort of impose an unnecessary hardship for the user. Gives rise to a necessary hardship that only the board can provide relief to. So we also have some supplemental findings that we have to approve because of this variance. First, that the conditions on which the application is based are unique to the property for which the variance is sought and are not generally applicable to other properties within the same zoning classification. As I said, this is a long-standing use specialized use within the sort of industrial general zoning, MI zoning district. It's caused completely by the code and the critical area management program manual, additional standards that we apply to areas within the critical area itself. It's not based on exclusion or desire to increase the value or income potential of the property. We've seen testimony today. We've seen there are reports that have been proffered to us today that's going to also reduce sort of idling time, get us a more efficient use of this time, so that we can get more, sort of more butane in the storage facility, trucks in and out quicker. It will not be injurious to other property in the immediate vicinity. This is contained by other industrial uses surrounding it, and the existing maritime use will continue to be operated next to the property. I do believe that the variance is in harmony with the purpose and intent of the code, as stated before. There's no urban renewal plan. It is not precluded by the city's comprehensive master plan, but it actually is in compliance with it, and this is not in a historical or architectural preservation district. I believe that the variance will not otherwise be detrimental to the or endanger the public health or security. And so there are additional state-imposed variance standards that we must consider for this application. The Natural Resources Article, Subtitle 8, requires that we must overcome the presumption that the specific development activity for which the variance is required does not conform with the general intent of the Baltimore City's critical area management program. Beginning with the proposed storage that must comply with the goals set forth in Section 1 of the manual. It is been sort of posited to us today. We have not received any testimony in opposition that the development activity will actually reduce the adverse impacts of human activity, namely the removal of nearly 15,000 square feet of impervious surface, and that will be replaced with natural turf, will result in a net negative reduction in nitrogen, phosphorus, and total suspended soils in the area. This, in turn, will serve to sort of at least conserve or perhaps hopefully restore sort of, fish, wildlife in the area. And it does, promote, a more attractive and sustainable environment for the Baltimore's residents, because of its location. The bar is very low. So the 3 trees and a little bit of turf improves what we already have there. Moving on to the COMAR variance standards, Section 27 of the COMAR requires that the critical area variance application be referred to the Critical Area Commission, who have sort of deferred to the opinion of the board by saying that as long as they meet each requirements, then they have no objection to the project. So these requirements also include special features of the site or special conditions or circumstances peculiar to the applicant's land or structure. A literal enforcement of the critical area program result in unwarranted hardship to the applicant. We do want the applicant to continue to find ways to improve their business and their property in the cities to keep their business operating and to do so more efficiently. And so this project proposes a solution that gets us there. A literal interpretation of the local critical area program would deprive the applicant of a use of a land or structure permitted to others in accordance with provisions of the program. Because the proposed use would serve as sort of an intensification of a grandfather use, a literal interpretation of the Camp Manual would not allow this to happen at all. And the granting of the variance will not confer upon the applicant any special privilege that would be denied by the local critical area program to other lands or structures in accordance with provisions of the local critical area program. I think this applicant has shown and posited that they have met all the requirements for such a use in the critical area program. And this is a grandfather in existing use, and this would probably have, if this were totally a new use, of course, different standards will apply. Make sure I got through those. Okay. I'm going to get to the prohibited use exception. I think we've met those standards. So, the legal standard for the critical area prohibited use, for exception to the critical area prohibited use of the zoning code, there has to be no environmentally, we have to find two things, I believe. I'm sure that there's nothing else we have to find. Two things. That there's no environmentally acceptable alternative outside the critical area program, and that the use is needed to correct an existing water quality or wastewater management program. That any alternative, alternative that would exist outside of the critical area program would still need to have trucks traveling through the city to get the butane to this storage facility so that it then can be used and distributed throughout the region. This project proposes a way that we can minimize the time that existing traffic that's already coming into the facility has to idle. And so I think this is the best out of all of the alternatives for solving the problem presented to us today. And the use is needed to correct an existing water quality wastewater management program. Of course, the environmental impacts of having, idling, trucks sitting at the facility, if we can find any ways to just make that time less, then it's going to help us with our existing water management and wastewater problems as we currently, are enjoying our, what is it called, pistachio tide in the city. So for all of these reasons, I do find that they meet the standards for prohibited use, for an exception to the prohibited use critical area prohibited use standard in the city zoning code. So for all those reasons, I am a yes for the application as presented to us today.
I am a yes as well.
Also a yes.
And I am a yes.
Thank you very much.
No problem.
Probably could have just adopted her rationale findings, but
Okay, now moving on to BMZA Appeal 31 North Smallwood Street, Terrell Hawkins for the applicant. The project is to use the property as a community center, requiring conditional use approval and variances to the minimum lot area and off-street parking standards. First, we will hear from planning and staff.
So appeal number 250032 for 31 North Smallwood Street. Planning understands we have three requests on this appeal. First, for the conditional use for a community center. Second, for the variance for parking. Third, for the variance for the minimum lot area. So planning just notes that the applicant also owns the property next door, 29 North Smallwood Street, which is currently an operating community center run by Fayette Street Outreach Organization. And that was approved in 2017 by the board, and it continues to operate today. Regarding the conditional use on the 31 North Smallwood site, planning finds the requirements of section 5406 were met, and that the impact of a community center at that site next door to the existing center would not be any more impactful than anywhere else in the zoning district. So regarding the two variances, first to address the off-street parking variance, we understand that the applicant has worked out an arrangement with the property owner across the street of a multifamily, which is 2 North Smallwood. So they have an agreement to use the off-site parking at that location. However, there is a section of the code, section 16401, that allows for off-site parking. However, to meet that standard, the off-site parking has to be possessed by the title holder of the subject property, which is not the case here. It is just an agreement. So while there will be off-site parking available to patrons of the community center, the parking variance is still required. And planning is supportive of that variance. The other variance required is for the lot area. The subject lot contains 1,135 square feet. Again, planning notes that the applicant is also the owner of the property next door, and that property contains 2,233 square feet. The minimum requirement for a community center in the zoning district is 3,000 square feet of lot area. So planning is recommending approval of this appeal contingent on the lot consolidation of the subject property and 29 North Smallwood. The applicant has stated that they were already prepared to pursue the lot consolidation, but conjoining those two lots would raise the total lot area to over 3,000 square feet, thereby eliminating the need for the lot area variance. So again, the recommendation is approval of the conditional use contingent on consolidation and approval of the parking variance.
Thank you. So let's start with fire rated capacity. Have you received your fire rated capacity for the property? I'm sorry, first, did you stand to be sworn?
You raise your right hand.
Oh, yeah.
Do you swear or affirm under the penalty of perjury that the answers that you give and the statements that you make will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
And you're Mr. Terrell Hawkins?
No, Terrell Hawkins is actually on, he's out of the country, so
Okay.
I'm standing in for him.
Can you go
My
ahead?
name is Brandon Carter. I'm with WC Design. We're a design firm assisting the client and owner in trying to get this variance and conditional use approved.
Or was that Brandon?
Brandon.
B-R-A?
Yeah, B-R-A-N-D-E.
Thank you.
I just want to make sure I have this right. Do we know how many spaces are for off-street parking are needed, the variance?
So I don't have the exact number of off-street parking, the exact number of off-street parking that we need. What we were hoping to argue was that kind of due to the condition of the existing lot and its status that we would be able.
Make sure your microphone's on.
There we go. Due to the existing kind of condition of the lot and the.
Okay, before we get to that,
Yes.
we don't know how many spaces to grant you a variance for without the fire rated capacity of the center itself. Because the standard is 1 per 10 persons of fire rated capacity.
Right.
So we need that number to be able to grant any off-street parking variance.
So I have the number. Give me a second here. Just to pull this up. I have, so we have, our occupancy total is only gonna be 53, so we would only need 3 offsite parking spaces, which we have more than
You said 53?
53.
So it would be 6?
Oh, sorry, you said 1 per.
It'd be 5.3, but under the code it would go to 5.
Okay, 5.
Oh, I'm
Okay,
sorry,
all right.
I misheard your
Sure.
number.
I just want to make sure we had that number, but
Yep.
put a pin in that. Let's start with the conditional use. Tell us a bit about your community center.
So Phase 3 Outreach has operated in West Baltimore for over 20 years, almost 30 years. They've been in since 1994, serving to kind of improve the health and welfare of the residents of the neighborhood, providing different things from food drives, educational services, youth programs. And so they have been a mainstay for a long time. They previously consolidated 2 lots, 27 and 29, into one building, knocked down the wall to make a large community center space. And so at this current point, they are at capacity, right? They're unable to include additional residents as the neighborhood continues to grow. So their initial thought is with the inability to move to another site, expend capital to do that, they acquired the neighboring building 31. They want to create a small opening on the first level of that building to be able to connect all those uses together, and then bring the capacity up, and then also add additional services for the community into this new space.
Any questions about the conditional use?
Actually, I want to Maybe I'll wait till we go back to the parking.
Okay,
I'll
okay.
put it in it. All right.
Any other questions?
No questions.
Nope.
No question.
Okay, given what we've read in your application, what we heard from you today, you know, I've have not heard, any testimony, there's no opposition. And so I believe that operating a community center at this facility next to an existing community center, which would be essentially an expansion of a similar use, will bring negative effects that are above and beyond what we would expect of a community center anywhere else in the zoning district. And so for that reason, I'm a yes for the conditional use.
Yes.
Also a yes.
And I'm a yes for the conditional use.
Okay, next, we have a minimum lot area variance. So we heard from planning about the request to consolidate the lots. Where are you guys at in the status?
So I guess there's one thing about that I didn't chance to clarify with Justin prior to this hearing about the lot consolidation. So the overall goal of this project was, well, actually, let me back up. This project was part of a grant from the state of Maryland for the, I believe it's the regional neighborhood initiative. But the neighborhood improvement, yeah. So the initiative from the state of Maryland to improve the neighborhood, they are essentially on a timeline with that grant. We started this process earlier this year. We went through this essentially when the city began to re-implement a new screening and permitting system. So there were some delays that pushed us back. We initially, from our previous information that we had gathered about the property and not being able to find a substantial amount of information from Baltimore City about how the previous the previous buildings were classified, we decided to go with the variance. That was going to keep us on our timeline that they have until December 31st of 2025 to complete this project and get everything moving. The lot consolidation, we spoke with Justin. He let us know that process will take approximately 2 to 3 months, give or take, with some other moving parts in there, and that would really push us past that timeline that they were going to be held to by the state. So we were going to seek this direction in order to get this moving for them and keep them on track for permitting and construction. So the lot consolidation, as a last resort, we are prepared to submit all documents for that. That would require us to, again, go back in front of the state and, unfortunately, probably not meet the requirements of this grant. So that's the background on where we are with the process, kind of on where we landed and why we're here to request said variance.
Okay, but you guys, if I understand planning's recommendation is that they are in favor of the variance, and they would like to see the lots consolidated because that would sort of make the properties in harmony with the zoning code, because it would be larger than 3,000 square feet.
Right.
And so there's a way we can sort of push you guys firmly into that direction while still giving you the variance that you need to allow your project to move forward by the deadline to meet your state grant, which is, sort of approving it a contingent upon you guys sort of submitting an application for consolidation at some point in the future. That will sort of make this future larger expanded lot in harmony with the code.
Absolutely.
You guys, just want to make sure you guys understand why we are recommending that and why we consider it. Justin, was that a good sort of summary of why that recommendation was made?
Yes, and the context that the applicant added about their grant deadline is part of the reason we arrived at this application, as opposed to just having them postpone and get the lot consolidation and come back for the expansion of the conditional use, which would, of course, add months to the process. We arrived at that recommendation so they can just get their approval for the conditional use contingent on pursuing that lot consolidation.
Okay.
So, question, are we talking about pursuing a lot consolidation or actually consolidating the lots as a condition?
I was thinking for our standards, the pursuit of, we can hand it off to other city agencies at that point, whether or not they receive the consolidation.
Well, I have an additional question, Mr. Walker, if you don't mind. So we are looking to, as we move into the off-street parking, right? So if these lots become consolidated as a condition, it's going to increase the fire rated capacity of the entire project if they're consolidated. So this is going to affect the overall parking requirements.
Right.
For the
So
project.
the existing community center has a parking variance because they don't provide parking. So under the code, when you expand the use, you have to provide the required parking for the expansion. So it would still maintain the same parking requirements per the fire rated capacity of the expansion of the structure.
So we do not have to add any additional conditions.
Okay.
These conditions just specifically as the variance is requested right now.
Okay. Okay, great. So,
Thanks for clarifying.
yeah,
And just to note, it would require the consolidation to be completed because a community center in R8 falls under all other uses, which have 3,000 square feet lot area requirements. So if the lot is not consolidated, it would not meet the requirements for the community center.
okay.
Gotcha.
Well, how would we write that in a sort of, just get to meet the matter? How can we write that in the resolution that will allow them to get their permits to continue keep their project?
Well, it sounds like, I mean,
They'd have to
if you're
consolidate
granting, if you vote to grant the variance to allow a lot size of, I forget the number, lot size of
Okay,
seven, whatever the lot size.
3,000 is the requirement, it would be over that if they're consolidated.
It's more, the opposite. I thought it was the minimum, or you need that much lot area, so that you can have no more than 3,000 square feet of a lot area is what,
No, it is the minimum.
okay,
yeah,
right.
So you need over 3,000.
Right, so that's, yeah, so the variance would be able to allow 1,700 square feet in lieu of the required 3,000.
okay. And
And the condition
sounds
could
like
be.
the consolidation condition would be a complication.
If you, I don't know how strongly planning feels about this.
Yeah.
I suspect it might be easier for the building permit process if it were consolidated, so it'd be on them. They would be they'd be incentivized to also follow through and get the
Okay.
consolidation.
Okay.
And planning, of course, handles a lot of the lot consolidation process, so
Okay, I got you. I see.
confident in that.
Got you. All right. So, any other questions regarding the minimum lot area variance?
No questions.
No questions.
Okay. Now I'm having brain fog. The first important question, of course, when it comes to considering application for a variance is regard whether there's a existing uniqueness or peculiarity regarding the property at issue for zoning priors. And so I find that perhaps the peculiar aspect of this project is that it is an existing lot next to an existing community center that wishes to have any sort of, I think that's the most, that is where I'm saying the peculiarity, right? The uniqueness of the sort of the lot. So strict compliance with the zoning code would sort of make a consolidation of these lots, sort of more difficult. And so, or will make the expansion of the community center use, more difficult. So, that is the practical. So I do see, I am finding a practical difficulty with maintaining strict compliance to the zoning code. This sort of, the practical difficulty is entirely caused by the code's requirement that a lot have 3,000 minimum, at least 3,000, I think 83 square feet of lot area for a community center use. 3,000 square feet lot area for community center use in this zoning district. It's not entirely caused by the applicant, and the applicant has shown that they have a willingness to consolidate the lots in the future, but in the future. So the applicant, it's not completely the applicant's fault. This is not based on the desire exclusive to increase the value or income potential of the property. They were to continue to maintain and expand an existing community center use here at this property. The variance will not be injurious to the use and enjoyment of of others in the property, of other property owners. I think that's evidenced by the fact that we have no opposing property owners here today who have submitted testimony in opposition of this application. And it is in the variance is in harmony with the city code, any existing urban renewal plans, city's master plan, and it's not in a historical and architectural preservation district. This variance will not be detrimental to or endanger the public health. It would be a credit to the community. And so for those reasons, I'm a yes for the lot area variance.
I'm a yes. I don't think we found uniqueness, but I think the facts and circumstances present exceptional circumstances, so I'm a yes based on that.
Also a yes.
And I'm also yes, and I want to add just as we create the resolution for the condition that the lot areas do get consolidated.
Yes. So moving on to off-street parking variance, which I believe we have for 5 spaces with a 53-person fire-rated capacity of the expansion that will require 5 off-street parking, a 5 off-street parking space variance. Strict compliance with this code will require some sort of demolition and other enhancements to the property that would force them to take away use that could be going towards the community center use and applying it to using it for cars. And so that's not what we want to do. That's not how we want the zoning code to act. So that to me is the practical difficulty that exists. And so because of that, and after reading, through the same standards and factors that I applied to the minimum lot area variance, it's my position that it would not be injurious or detrimental to the public health and safety to grant a 5-space off-street parking variance for this project. And so for that reason, I'm a yes.
I'm a yes.
Also a yes.
And I too am a yes.
And I think that's all 3.
For the resolution, the
Yes.
condition on the obtaining the consolidation, does that need to be, is there a time limit, or does it need to happen before building permit? I know that's one of the.
Yeah, well, I think as explained by Mr. Walker, it's going to have to happen before building permit in order for it all to actually go
They need
through
the zoning
consistently. And
approval
that's
just to get the Bernie grant.
right, and under control of the planning department, right? Thanks.
Thank you, guys.
Thank you.
Chair, can we go off the record for just a minute?
Yes.
Just need to get some water.
For sure.
Thanks.
Okay, we are back on the record at 2:31.
So we have an issue brought to us. First, I want to see what clarification about what we voted on for the minimum lot area variance. What contingency did we put on that, on approving that variance?
Approved on the condition that the lots be consolidated.
Okay. What we have before us is a motion for reconsideration. Emergency motion for reconsideration. And I'm using my discretion as the chair to consider it as a motion for reconsideration. During the hearing, there was discussion about how should we make this variance contingent upon some sort of consolidation happening at the lot in a way that does not impair their ability to meet whatever deadlines they had to be able to get this project completed. There was discussion about that at the board level. And as I remember it happening correctly, I'm not sure if we ever had a meeting of the minds about what exactly that
Yeah,
should be.
I think I was looking at it from the perspective of one, I think we're good on the conditional use for community center because we can kind of look at that as a standalone address is going to become a community center. And that issue, I think we're in alignment on. I think it's the minimum lot area that is tied to occupancy.
Yes.
Once they consolidate the lot,
Can
then
we get,
go ahead.
Justin, is the minimum lot area
Okay.
tied to occupancy or just the use?
The minimum lot area is not tied to the occupancy. The parking is tied to the fire rate
Okay.
capacity.
It's the use.
The minimum lot area in R8, a community center for Balkan Yard falls under all other uses. They specify row house dwellings, multifamily dwellings. Then there's just a broad all other uses category. And the all other uses category is 3,000 square feet of minimum lot area.
Okay, so that's where that requirement hails from, because it's an,
Okay, the use.
yeah,
Okay.
the use.
So where I was coming from is sort of looking at it as the building permits that they're going to have to get. My assumption was that was tied to the single address, the single lot. Because when they file for the permits, they're going to have the address of the new building on it. And we want to let that, and I want that to move forward so that they can meet the deadline around their grant. And I think, as we all know, the delay in permitting was not, according to testimony, was not the fault of the applicant, but a fault of the permitting challenges. So I think my recommendation is to sort of narrow the focus and just look at the single building that needs permitting in order to do construction. I think it is appropriate for planning to raise the issue of consolidating the lots because eventually there's going to be an opening between the two buildings. And I would just say, from a construction standpoint, how I would approach that if I was in their shoes, I would get the permits for the single address that we've said can be a community center. And we said that it can be a community center even at this reduced square footage size. They can go get permits. That should be enough. Now, when they decide to cut the door between the two properties, and that's according to the plans, that looked like really the only change that was going to happen to the existing address, that they will need to consolidate the lots before that happens. And so I think from a construction standpoint, you should be able to get the permits for, I would say, the majority of the work that you need to complete. From a timing perspective, the applicant is in agreement that they plan on consolidating the lots. And so I think if I would defer to you, Mr. Walker, are you saying that planning is recommending that we put that we also state that they need to consolidate the lots in our ruling? I would say they're here today to say, can we start construction on a community center that is smaller than what is required by the zoning code? I would say yes. They will have to get a permit for connecting the two buildings. They will need to have consolidated the lot. That said, my experience with Bernie grants is that will be a clear and adequate case for the state of Maryland that if for some reason the consolidation of the lots takes longer than they're able to get the permit for the hole in the party wall, then that seems like we're doing our best to get them as much permission as they can to show progress that will satisfy the requirements of the grant and keep them in good standing. So to me, that's where I said, I don't know if we need to place the condition of consolidating the lots, because really what we're saying is a community center can be at this new address and that it can be smaller than the minimum square foot. And those are the two questions at hand. I think it's completely appropriate to say, as the planning department, these need to be consolidated. The applicant has stated that is their intention, and they will have to do that before they're permitted to do any demolition on that party wall and connect to the two properties. So to me, I don't feel like I have to rule on that because the system is going to force them into it. I don't know.
They can't have it
Well,
open without-
I don't disagree with that. I don't disagree with that. However, if we don't show some type of condition, then there's nothing to say that this specific project couldn't get done again somewhere else. The condition that I think is important to this is that the fact that they have an abutting building with a use that they want to continue. So I asked the question, would it make more sense to rephrase the condition to say post-occupancy? Is it even necessary? Because if we don't impose a condition, then what's to say that another project comes to us that wants to do the same program, but there's no condition
At this
provided?
location?
Not at this
No,
location,
at a new
anywhere else
location.
within the zone.
So
I understand. But-
Yeah,
So,
so,
go ahead.
so-
Is it even necessary?
yeah, and so, David, I think I just want to make sure that I understand, again, also brain fog, that the thing that says, we don't want to set precedent, that was the word.
Exactly, that's
Your,
exactly- yes.
your concern is that without the condition, we might be unknowingly creating a
Correct,
precedent that
correct.
has somebody else coming and asking for
Yes.
conditional use for a community center without the appropriate minimum lot area. And so we don't want to necessarily take that away from BMZA.
You phrased it better than
unknowingly.
I could.
Yeah, okay, I get that. So yes, I agree. I think a conditional use that just says post-occupancy, that's a,
Is that acceptable?
I mean, I think the board can.
yeah, I would
makes
say,
sense.
What conditions
yeah,
you deem
I would say
appropriate.
either post-occupancy or we could say something as has shown meaningful progress by the standard of the planning department to demonstrate that they've shown meaningful progress to consolidate the lots while we are still allowing them to begin construction on the community center at the property. So that way they can, whatever the standard of meaningful progress is, that's going to be kind of on the planning department and the permit office, right? And so,
Respectfully, if I may
Yeah,
interject. So
you-
it sounds like, because I think you're solving for a problem that you don't need to solve for. You're trying to solve for the precedent issue, and every case is on its own facts. So if it were the same location and the same exact facts, then there would be some precedent. But
Oh, I
other than
see.
that, there is no
Okay,
precedent.
yeah,
So
see,
if someone
that's-
comes around across the street with the same setup, but unless it's exactly the same, then you're not bound to your
right, so I
decision.
think that's what I mean.
Factual
If we
that's
say,
that's my
yeah,
concern.
I want to narrow because if I narrow the focus and I say, in another neighborhood across town, somebody else wants to do a community center in a row house, that would still have to come before the board.
And you're not bound.
And we're not bound
And
to
you
precedent.
do the analysis the same way. You do does it qualify for a lot area variance? Yes or no? And you
Yeah, and so
decide
that's
on the
where
facts.
I wasn't
Okay.
concerned
So
about
I would
that
say,
part.
it
Yeah.
sounds like the board, over the objection of planning, finds there are enough facts here to grant a lot area variance, and therefore could grant it. And given the discussion you had about, as a practical matter, they're gonna have to do it eventually to consolidate, planning's concern is addressed about future consolidation. And
Yeah.
So
What
my
we're trying to solve for is-
my recommendation would be just to grant the variances and then.
Yeah, that's what I said. I
There
was
we
going to
go.
grant
Yeah.
the variance and not
That's
put
the
the
buck.
condition
Yeah.
in.
But just to be clear,
Yeah.
I think one thing you said, I think the mere fact that they get a permit to cut a hole in the wall,
Mm-hmm.
I don't think mandates consolidation in and of itself.
Mm-hmm.
That's true. Well, actually,
But-
Dave may have more
but-
experience as an architect, but I mean, I've seen different circumstances where where it should have been required potentially, but it has not been required.
But in the existing property that they occupy has also checked the boxes and has gone through this process to,
And indeed, it would be in their interest to consolidate for just one bill, and everything would be a lot easier.
yeah, there's,
So
it's interest in harmony, and I get that, from the planning department's perspective. But I think for me, the narrow thing that I am saying as a BMZA board member is saying, I am comfortable with a community center operating in a smaller space than the zoning law requires. And in this instance, based on the evidence provided. And so thank you, Justin, for helping clarify that we are not setting precedent today.
As long as we're not setting a precedent.
Yeah.
Yeah, okay.
Then I think we can issue it without conditions.
So, you know, we've heard testimony today that, you know, pretty much, let's go with Occam's razor. The simplest choice is the best choice. And so I don't want to say we're over planning suggestion, but we are going to make sure everybody gets what they want. So instead of approving the minimum lot area variance on a condition that a consolidation is obtained, instead we're just going to approve the minimum lot area variance on its merits, because it seems like that we all agree that we believe it meets the standard for operating a community center on a lot smaller than the zoning code requires.
Yes.
This will not be contingent upon obtaining a lot consolidation. That will be an issue that will be raised at some other point, if it's relevant at all. And so I am a yes for approving the minimum lot area variance without any contingencies.
I'm a yes.
I'm a yes, and just to note for the applicant, our decision here does not necessarily override a decision or information that you might receive from other, like the permitting office. So that I'm comfortable with that. And so, yeah, I'm a yes.
And I will also be yes, retracting my previous contention.
All right, thank you guys.
Thanks,
Appreciate
guys.
that
Thank
for
you.
bringing that to our attention quickly.
Thank you.
Yeah. Now calling the winner of the day, BMZ Appeal 2540, 1637 Gwynns Falls Parkway. Nyasha Miller for the applicant. The project is to use the property as a dwelling unit multifamily, 4 dwelling units, requiring variances to the bulk regulations and off-street parking. Is there any opposition to this case today? No opposition. First, I want to ask you to stand and be sworn, and then we'll hear from planning and staff.
Do you swear or affirm under the felony perjury that the answers that you give and the statements that you make will be the truth, the whole truth, and nothing but the truth?
I do.
Tell us about your, planning and staff.
Okay, so 1637 Gwynns Falls Parkway under appeal number 250040. The request is to use the property, which is located in an R7 zoning district, as 4 dwelling units requiring variances for lot area. The lot currently encloses 1,800 square feet and has a pre-existing approval for 3 dwelling units under case BMZA 2020-00156. The requirement in R7 for 4 dwelling units would be 3,850 square feet, requiring a variance of 2,050 square feet, or approximately 53%. To run through some history of this, the property received authorization for 3 units and an efficiency unit in 2009. Of course, the code no longer recognizes efficiency units, but permits were, the authorization was granted, but we understand permits weren't pulled. So following 2009, the parcel, that authorization was granted under the R8 zoning. So there's been a material change in conditions that between 2009 and now, in 2017, the zoning was changed from R8 to R7. So in 2020, under appeal BMJ 2020-156, the dwelling got approval for 3 dwelling units, which still required a lot area variance, and the property is currently approved for 3 dwelling units. Because of the significance of the variance at 53%, the change in material conditions from R8 to R7 shows intention to limit density in the area. Planning recommends disapproval of the appeal.
Thank you. Tell us about your project today.
Hi. Yeah, so I have a property there. Like you said, there's 3 units. Actually, before I even purchased, I came to the zoning board here, or administration downstairs, just to see like how realistic it was gonna be for 4 units. And I got obviously some things like in the archives or something that said that you guys approved it for 4 units in the previously. So, which is what prompted me actually purchasing the property. And then there were permits pulled before then, like 2007, for 4 kitchens, 4 bathrooms, 4, furnaces, all of those things. So there's a also framing. There's also like a full functioning unit in the basement with 8-foot tall ceilings, and it's 50% over 50% above grade, and with 2 separate entrances and windows and all of that, and it's all there. And it's just underutilized. So the building altogether is underutilized. And just knowing that it was approved at some point before, I know that you guys, like your zoning codes from R7, R8, R7, I'm sorry, this is my first time doing this, so I don't know all of them, but I understand it's for less. But with those permits that were pulled and issued, and the approval of it, I have a property with a full unit in the basement that I cannot legally use. So right now I'm using it as my primary residence, so I personally live there. So I'm taking it up, but I want to legally rent it out. And obviously there's a lot of investors in the area, and I talked to them and they're like, we would just rent it out. And I was like, okay, I don't want to do that. I also want to encourage that either. And this is kind of already set up this way, and I kind of acquired it this way. And I think the guy downstairs, Mr. Wilson, said something like it may have gone vacant for a period of time. And then another owner came in and they just got the variant for the 3, just like 85% of the block that I've looked at. But I don't even know if they knew that, like in the archives, that it was approved for a 4 unit at some point. So I guess speaking of precedents, since you guys have been talking about that, I'm in the same exact building. I just want to have permission to kind of go back. And I know that you guys went from R8 to R7, but it is a big lot. All of them are big lots for R7 code, which is, like he said, it's supposed to be 30 something, or like 3,000, over 3,000 square feet, but all of them are like 1,800 square feet. So we already have to get precedent. I mean, we already have to have, a variance for the 3. I'm not changing anything in the structure. I think there were permits, I have it here, for just electricity, furnaces, extra kitchens, extra bathrooms, and it's all done. So.
Any initial questions?
Right, just wanted to clarify. So the barrier is you went to go get these rental units certified through the process, and then you were told you can't, as a property owner, you can't legally rent one of these units.
Well, I think I kind of knew that just because it was zoned for 3. So I think maybe I'm making the assumption that I couldn't get it because it's only zoned for a 3 unit and not 4.
Okay, and so now you're saying, but because there is many moons ago, a 4th unit was constructed, you're not going to be doing any additional construction.
Right.
You're just asking for permission to legally rent the 4th unit, and that would require it to be rezoned. I understand that part.
Right, and many moons ago, 2010, it was zoned for a 4 unit property.
Mm-hmm.
Right, which we found, like, I think one of the people here, they said, we don't see it, but I found it was in the archives or something before you guys went paperless. So it was already issued that it could be zoned for a 4 unit property.
Yeah.
Not just that it's there, but it was
Sure.
issued there, and there are permits before that for
Yeah, I
everything
understand.
that's there. Yeah.
Yeah. It's a neighborhood of row houses that are a standard size of row houses.
Yeah. you said that all of the existing row houses, are they all multifamily dwellings?
Okay, so I counted the mailboxes. So some of them are full. Say that you said all multifamily, yes.
Yeah.
So when I counted all of the mailboxes, a little over 85% were all multifamily.
Okay. So I'm gonna address the first part. The zoning code has a provision related to the discontinuance or abandonment of a use. So if a use for some reason has not been used for 12 months more,
Yeah.
then the formerly approved use here would be 4 dwelling units ceases to exist. And because it's non-conforming, you now have to seek a new variance to get to 4 dwelling units.
Right.
When we're looking, before we can sort of a threshold question for our board that we must consider when during an application for a variance is whether there is a peculiar or unique aspect of the property that makes compliance with the zoning code sort of an unnecessary hardship. And so in a city built for row homes, you know, it can be difficult. A city built of many row homes, it can often be difficult to find unique or peculiar characteristics about a property. Hence, you know, variants are meant to be seldomly granted. So in this case, what we need you to help us find is, you know, what makes this property so different or unique or peculiar compared to others in the R7 zoning district that, you know, you cannot comply with the requirements of the zoning law. So when we are allowed to be sort of to broadly consider the characteristics of the property when considering peculiarity and uniqueness, but it's on the applicant themselves to sort of point out those circumstances to us. So I asked my other my fellow board members, have we seen any unique or peculiar aspects of this property?
Well, I think what's unusual, unfortunately, it's not a form thing. It's the fact that it was approved for 4 units. We typically don't see
And
that.
set up for 4.
And set up for 4. So what we typically see is homes that come with multiple BGE meters and doorbells and all of those things, but they were never properly zoned.
Yeah.
They just existed.
Yeah.
And so then a new buyer comes in and says, but there's 3 BGE meters, why can't I have 3 units? And we say, well, we can't find anything unique, and the zoning dictates X, Y, and Z. I think what is interesting to me in this case is that there is clear evidence that at one point it was zoned for 4 units, whereas, and I could be incorrect, but that seems unusual, but it doesn't have to do with the form of the building, and that typically is.
That means there are party walls, there are utilities inside these buildings and appliances that sort of are fixtures to the building. So I think we can consider that when we're thinking about unique physical characteristics of the building.
Yeah.
And if I may just correct the status, so based on our notes and our records that are in your staff notes, there was a BMZA approval in 2009. It was case 393-09 to get to 4 dwelling units, but I don't see it on here for one. But also, they never got the permits to do that work. Then later on, there was well, this UNO was not issued. So like the last officially issued one. So they got the approval for 3 dwelling units and 1 efficiency unit that the BMZ approved. And that might be 01. Maybe that's why it's older.
And then they never got.
But then the UNO was for 3 in 2008, and then 2021 or 2020 they came back for
So according to this, just for clarification from staff, so that I understand, a former property owner came before BMZA and was approved to have 4 units in this building.
Technically, I think 3 units in one efficiency.
And
unit,
that was
which
an
no
old
longer-
thing, and I understand that. So let's just, for
Yep, I understand.
for simplification, and then that property owner, we can assume, or like we're trying to infer based on the record, that then they went ahead and constructed the efficiency unit based on that ruling, but they never actually filed UNO and permits for that potentially based on the record.
As I understand these notes here, so they filed but never got the final sign off. So if the final inspection would be here if they had gotten the final inspection. So there was a initial filing, but then maybe there wasn't enough square footage for the unit. Maybe something else happened. Maybe they walked away. But
Yeah.
the recession-
So I think to the applicant, and I know you want to say something, but let me phrase it in a question, and that might get you where you're kind of wanting to go. So you went into the archives and you found and discovered that it had been previously zoned for 4 units. When you were looking in the archives, did you find a use and occupancy permit for 4 units?
So I didn't look for that. This is all news to me. So, but what I did, I looked for permits and the things that were issued, and so because it was in the archives and I couldn't like get a copy of it to understand why the board approved it. I did see that in 2007, all the permits for 4 kitchens, 4 meters, 4 baths. So it might have already been created because their
I
permits were in
see.
2007. And so that's what I'm looking at.
Yeah.
And so,
That feels right for 2000.
yeah.
BMCA.
and it was completed and signed off on in 2008.
Yeah,
And then
yeah.
2009, they came in and said, hey, can we make this a 4th unit? And it was like approved. And I don't know what was surrounding that because I couldn't read it.
Sure.
But the permits existed before that were signed off on for this space to already be a 4th unit.
And that permit would have been for construction, but they might have not gotten the final use and occupancy.
And I will say that there are 3 dates here, like going all the way across that said like signed off on.
So we do
And
know in
issued.
2007.
Okay, they built it and then they got the UNO. Is that right? Am I reading that right, Justin?
This permit, the 2007 permit, yes, would be like to install 4 bath, 4
Yeah,
toilets,
and then
4
the
sinks.
dates, one of those,
So
because I can't
so
see the
this
column.
one, when this final was actually issued.
Yeah,
So
okay.
actually it was fine, and the inspections were completed for the building piece, but then they supposed to get a UNO, which I'm not sure.
Yeah, hey, that happens.
And I'm not sure either.
Yeah, that happens.
One more note on like the precedent, unlike the last example, like if the zoning had not changed like if it were still R8, then it kind of would be same facts and same things, but the change in what happened in 2009 versus today, when your predecessors approved to have 4 units and now it's a new case before you, is that the zoning, underlying zoning change, so it's like a bigger variance.
Right, and so if it had remained R8, it would be,
If I was a lawyer, I'd argue that you are bound by the prior decision because the facts haven't changed.
right, okay. And then, but because it got rezoned at R7, question for you, Justin. After Thursday, and when it goes back to council, there's potential that this could become legal on its own and not require.
Lot area changing? I don't recall.
I forget which one.
Yes.
I don't know if minimum, I think it's just it's
Just a bulking
multi-
yard.
Bulking yard.
Bulking yard.
Like
But
the-
the
like the
multi,
set- like
but
the setback.
I'm talking about the multifamily dwelling, though. That's a different one.
Oh, that's gonna be, I mean, it's still the planning commission, so that's
Oh, that's still,
That's at planning commission on Thursday.
information session, so there'll be,
And so it'll take a couple months. If
Yeah.
it gets out of planning, they've got to vote, then it's got to go before
Gotcha.
council. So,
it might not make it through the end of the year. Boy, it'll be a rush to get December city council meeting probably at this rate.
and so just so you know, what we're discussing is that there are currently on the table some changes to the zoning code that I can't speak to your exact property, but my understanding is it would make it easier to create more density in neighborhoods, essentially. And so that's on the table. It is a bill that has been proposed by council and the mayor's office, but it has to go through a fairly lengthy legal process. So it's not something that, if I were a property owner, it's not going to change in the next 60 days or something like that, like some of the other zoning changes that have been on the table. But you posted that you were coming here today. You have the posting on your property?
Of course.
Has any of the neighbors reached out to you? So there's no opposition here today?
Right. It seems planning's largest objection was the intensity of the variance.
Correct. Is
That's
that
53% reduction.
welcome back,
Yeah.
Mr. Walker? Just, I want to be clear on what planning's objection was based on. It's the degree of variance, correct?
So yes, it's the degree of variance over 50%. Also that since the prior approval for 3 dwelling units and 1 efficiency unit, they have downzoned the neighborhood under transform. So
Yeah.
with both of those facts, that's the basis of our recommendation for disapproval.
Well,
And the findings for peculiarity.
so I just want to put it out there. I'm comfortable with this, and here's why. I understand planning's position, but I think the position is counter to some of the goals that we have in the city to increase density. And that is a goal that the city has. And I know it's a goal because the mayor's put in a bill that says we need to increase density. And so I understand that my personal view on this does put the board in a position where we are granting a variance that's larger than we typically do. We could also be setting precedent. And I'm okay with that.
Well, I think maybe we can, and I'm for
Or we're
approving this
opening
as
it.
well.
Yeah.
But I think maybe the way to go would be to go back to where we did the other one, or at least my position was on one of the prior cases, that this particular case, the facts and circumstances of this particular case constitute exceptional circumstances so that we can grant a variance.
Yeah.
That your next door neighbor may not get that if they come
Right,
to us.
sure.
That's what I'm saying, because I want to make sure that we're
Yeah.
dealing with your property. and
Case by
your
case
property only.
basis.
Thank you, Frank.
Can I
Any-
add
case by-
something before y'all get too deep?
Yeah.
So they also need a variance to the off-street parking.
Right.
Yeah, I'm fine with that.
Yeah.
Okay, just
That was
making
that's
sure
the
y'all
easy
know.
one. Yeah,
Okay,
that's the
cool.
easy one. Could you describe the current conditions of the property in a little more detail? What, if you were walking the front door today, what would we see? How many units are there, except stuff like that?
Say that one more time.
How many units are there? What are the existing conditions of the property?
It's beautiful.
yeah.
No, okay, so do you want me to just explain like when
Yeah,
you walk
the
in?
layout,
Okay, cool.
yes.
So when you walk in, there's that first,
You might have I think you have floor plans in front of you and
I
your board
do.
packets too. But
Yeah, I'm locked
I was
out.
gonna
of
say, I'd say-
SharePoint. I'm locked
Okay.
out of SharePoint.
I worked
I
really
have
hard on
them.
these.
I can try to pull it up while you're talking.
Okay, when you walk in, there's a first floor unit, so each story has its own unit. The first floor it shares with a laundry room that's open for the whole building. It has been updated in 2021 when that second owner purchased the space. So there's a first unit. You walk in, first laundry room, first unit. There's a private entrance for the ground floor level because it slopes down, obviously, so that the ground floor is actually over 50% above grade. And then there's stairs that go up at each level. The whole unit is the whole floor is for one level for one apartment. Excuse me. Downstairs, they have 2 separate entrances. The first one is when you come to the foyer, and there's an entrance to the basement right there. But also there's an entrance to the back parking deck. And the reason I was asking for the parking deck because I didn't want you guys to be like, oh, it's going to add more cars. And I was like, okay, well, let's take stuff off of the street. Is there's plenty of parking, but I was trying to think that way. And the ground floor is 950 square feet. Each one is between 850 to 1,000 square feet on each level, but each apartment has its own the full level.
Okay.
But what else are you
So
asking? I'm sorry.
there are 4 apartments existing today, or 3?
Yeah, you're currently living, you said, in the basement apartment.
Exactly, in the ground floor.
Okay.
I stay there because I couldn't legally get a
Rental
permit
license,
and I couldn't a license for it.
Yeah.
So I personally live there, and they're all set up with separate entrances. Actually, the ground floor has 2 separate entrances. There's fire escapes because I have a deck that's built on all the way up to the top.
Yeah. If you would have to settle for 3 dwelling units, what kind of modifications would you have to make to the property as it exists today?
Nothing. It would just be an
Unused space.
unused space. Nothing would change. It was already set up for 4. No modifications whatsoever.
Okay. How you guys?
I think I appreciate Frank helping to frame that we aren't. One of the things that I always want to be cautious of is our ability to set precedent and put other city agencies in positions that are challenging for them. I want to be. I don't want to create problems. I don't want to create too many problems for people, but I do think that this is a unique situation.
Absolutely.
That it had been previously approved for 4 units under the old zoning code, was renovated as such. Permits were seen as final, so we can infer that there could have been a UNO for 4 units. And then all that really happened is it was downzoned. And
So it wasn't just down zone, it was also this
Right.
prior approval was abandoned?
yes, I understand.
Okay, just
Yeah.
clarifying, thank you.
Yeah,
So-
no, I understand. I think what I'm saying is that, like,
Yeah, well, that's why I mentioned facts and circumstances. I think if we look at
Exceptional circumstances.
I'm sorry, exceptional circumstances. We look at the entire picture, I think we can rationally come to a position.
Yeah. So appreciating that this is in a zoning district that had been downzoned under Transform Baltimore, and also appreciating the sort of unique permitting and zoning history of this particular property, I do believe that exceptional circumstances exist related to this particular structure. It's currently improved with what could be 4 dwelling units. Strict compliance with the zoning code would leave a portion of this existing multi-family property in the city unusable, which I do not think the zoning code would like to see happen, and which I don't think any member of this board believes that we have to force, in order to force compliance upon the zoning, upon this property owner. That's the outcome that we would like to see. And so this practical difficulty is caused by the code itself. In fact, this was approved with 4 dwelling units, and then the zoning changed for this property. It's not based on a desire exclusively to increase the value or income potential of the property. Is to make sure that this property is efficiently used and space is not wasted. It would not be injurious to the use and enjoyment of other properties in the immediate area. We have no indications of any oppositions from neighboring property owners. And I think it is in harmony with the purpose intent of the city code, urban renewal plan, our comprehensive master plan, and historical and architectural preservation districts. And it would not endanger the public health, safety, or welfare. In fact, it would get this property back into productive use for the city and its residents. And so for those reasons, I am a yes for the minimum lot area variance.
I am a yes.
Also, yes.
And I'm also yes.
Off-street, going to the off-street parking variance. So, strict compliance with the off-street park. So the unique or exceptional circumstances that exist here is this is a really a smaller row home property that is now a 4-dwelling unit multifamily property. Strict compliance with the zoning code would require the property owner to make significant alterations to the existing property just to fit a standard parking space. I believe it's just one parking space that was needed onto this property. And that is a practical difficulty that the board can provide relief to. That is a practical difficulty that is exclusively caused by the city codes and its requirements for parking spaces on multifamily or residential properties. And it's not, the need for this variance is not exclusively based on the desire to increase the value or income potential of the property, having less off-street parking spaces on a property doesn't make a property more valuable. It exists in a neighborhood that has existing, that does have existing off-street parking available and will not be injurious to the use and enjoyment of other property in the immediate vicinity. I'm going to take as evidence that that is true, that there have been no opposing applications from existing neighboring property owners. The variance is in harmony with the city code and other relevant laws, and will not be detrimental to or endanger the public health, safety, or welfare. And so for all those reasons, I'm a yes for the off-street parking variance.
Yes.
Yes.
And also yes.
Thank you so much for coming here today.
Yeah.
Thank you, guys. Before we go off the record, what we haven't done is in the beginning, we usually let staff kind of do their preamble, and I just want to make sure she understands to wait to do things until she gets her resolution and the timing of that. So can you all do the speech?
But please do not build without a permit.
Yeah, basically, so while they have made their decision today, it's not final until you receive the written resolution, which can take about 30 days to get.
Do I get that in the mail?
However you applied, so it'll go through Acela, because you applied through Acela.
Okay, so in the portal,
Yeah.
I'll get something, and then at that point, I can try to get the license, the occupancy license.
Then you take that to the permitting office.
You'll
and you should
need
be able
to
get it.
apply for a use occupancy permit, I suspect, since the last one on record is only 3 units, I believe.
Yeah, it's
So
only
they-
3
You'll
units.
probably have to apply for the UNO, probably have the UNO inspected and then issued, and then you can take that to the rental dwelling office.
Gotcha, yeah, I did my inspections, he told me to hold off to do the 4th until I spoke to you guys, and then after that, then I go back, and I think I'm
Great.
on the right track, I think.
Thank you. We're not off the
Make
record.
sure.
Thank you.
Thank you.
We are off the record at 3:16.